two cases going on at one time.
With a closed fist multiple times to the head, a stomp on her face, reportedly with a boot.
I do have a history, and I'm trying to work on that.
He might have an addiction to alcohol, but he has an addiction to beating people up. And in this one, you're stomping on the woman's head. Doesn't surprise me. You got drunk and violated rules, drank alcohol, and went to go visit her. Stop beating people up.
A guy with a long criminal history shows up to sentencing talking about addiction, prayer, and wanting his family back. The prosecutor already offered a deal. The victim supports it, and everybody in the room seems ready to move on. Meanwhile, the judge has the full report sitting right in front of him, and that thing tells a very different story. Should past behavior matter more than promises in court? Let's dive in.
We're taking up people in the state of Michigan versus Jason Ford. I know we're also here for an arraignment apparently on an alleged bond violation, but I'm going to deal with that after. George?
Thank you. First, I want to acknowledge it's typically a rather high threshold, and that the people, I myself, did not initially score that. So I want to acknowledge that. Obviously up to the court's discretion, but I think potentially could form a basis for the scoring. Factually, the defendant, the parties were living in a camper. The defendant returned to the camper. He appeared to be, according to the victim, he appeared to be using methamphetamine. He became confrontational, aggressive. She attempted to walk away. He then grabbed her, pulled her to the ground. She was screaming. He pulled off her shirt, her bra. She was naked from the waist up. He struck her with a closed fist multiple times to the head, stomped on her face, reportedly with a boot, resulting in large abrasions. And there were marks around her neck and throat where the defendant grabbed her by the neck to attempt to get her back in the camper. In the defendant's statement on the PSI, he did acknowledge that he was in an angry rage. So I want to acknowledge that I didn't initially score it, but I also want to acknowledge what I think formed the basis for the probation department scoring. And with that, the people would leave it to the discretion of the court.
Thank you. The answer is the court finds that is excessively brutal and is also more than is necessary to normally encompass a simple domestic violence. So the answer is no. Now, this is made a felony, not because of the degree of the violence, but because of the repetitive nature and criminal convictions for prior acts of domestic violence. This is much more than a simple domestic violence. Therefore, the court denies the challenge for offense variable number 7. And Mr. Denhound, I don't think we have any, but do we have any victim impact statement to be made?
We do not.
Here in the court. Thank you. Mr. Champion, allocution.
Your Honor, my client has taken responsibility in this case. He is since entering the plea has completed APS. He acknowledges that he has an addiction in this matter and needs to address that along with some mental health concerns. With that, I would ask the court to file the plea agreement, sentence my client to a term of incarceration with probation.
Mr. Denhound.
Thank you, Your Honor. First, I want to state that the plea agreement that was originally arrived at was arrived at with full consultation and support of the victim, Ms. Fountain. What she wanted at that time was she wanted the defendant essentially to be forced into treatment, which occurred in this case. Given the fact that the defendant had 3 prior felonies, 8 misdemeanors, and a history of assaultive conduct, I insisted that there be a felony on this case. Ultimately, based on the scoring and based upon alleged new incident, I guess I fully expect at this point that the court is not going to follow the agreement. People acknowledge that, but I wanted to explain the thought process that went into it, the input that our office had from the victim, and with that, we'll leave the ultimate sentence discretion.
It's at this time. Well, planned it this way. We're now going to turn to the bond violation allegations. Mr. Ford, this court issued a bench warrant for your arrest on November 24th of this year. The reason why it did so is that the court received information alleging that you had tested positive for the consumption of alcohol and that you had violated the no contact order by having contact with the victim, both of which allegedly occurred on November 20th. You have the right to challenge these 2 allegations at a hearing, and I can allow you due process. Nope, talk to your attorney first.
Just talk to you.
Okay. Yes, sir.
Your Honor, I take full responsibility.
Mr. Ford, it's now the opportunity that you have to make a statement to the court before I issue a sentence. Yes, sir.
May I stand or sit?
Whatever you feel comfortable with. I know you said you weren't feeling well earlier.
Your Honor, I want to say thank you guys for the chance for me to go to rehab. I know that I did violate with the drinking, and I apologize for that, but I take full responsibility, and I can't take back what I did. I can't take back this crime. I can't fix it. I can say I'm sorry, but I'd rather show it. I do have a history, and I'm trying to work on that. I am addicted. I'm an addict. I am having a hard time with alcohol, and that's why I was asked when I do get on probation if I can release on scram. As